Welcome to Law Made Simple, where we decode complex laws into everyday language. Today's topic is one that affects every family. What happens if someone dies without a will in India? This situation is legally known as intestate succession. Without a will, the property of the deceased is distributed according to personal laws. These laws differ for Hindus, Muslims, Christians, and Parsis. We'll explore each in detail, with examples and legal references. We'll also discuss what happens if a will exists but was made under pressure or fraud. Understanding this can help prevent family disputes and lengthy court battles. We'll break down laws like the Hindu Succession Act, 1956, and Indian Succession Act, 1925. Muslim inheritance is governed by Shariat principles. We'll also touch on how to write a valid will and why registration matters. This video is packed with insights for every Indian household. So grab a notebook and let's get legally literate. And don't forget to like, share, and subscribe to Law Made Simple. Let's begin. When a Hindu dies without a will, the Hindu Succession Act, 1956, comes into play. Section 8 of the Act lays out the order of succession. Class 1 heirs, like the spouse, children, and mother, get first priority. If no Class 1 heirs exist, Class 2 heirs like siblings and nephews inherit. For example, if a Hindu man dies leaving behind a wife and daughter, both inherit equally. If only siblings survive, they share the estate. This law applies not just to Hindus, but also to Buddhists, Jains, and Sikhs. It ensures a structured distribution but may not reflect the deceased's personal wishes. That's why writing a will is so important. It gives you control. Also note, daughters have equal rights as sons since the 2005 amendment. Property includes both movable and immovable assets. If there's a dispute, courts refer to the Act and family tree. Adopted children are also considered legal heirs. This law does not apply to Muslims or Christians. Let's now look at Muslim personal law. Muslim inheritance is governed by the Muslim Personal Law, Shariat, Application Act, 1937. It's based on Quranic principles and differs for Sunni and Shia Muslims. A Muslim can only will away 1/3 of their property unless all heirs agree. The remaining 2/3 must go to fixed heirs like children, spouse, and parents. For example, if a Muslim man dies intestate, his son may get twice the share of his daughter. This is based on traditional Islamic inheritance rules. If a will exceeds the 1/3 limit without consent, it's invalid. The law ensures fairness but limits testamentary freedom. There's no concept of equal distribution unless specified in a valid will. Widows, daughters, and mothers are all entitled to shares. Stepchildren and adopted children may not be considered heirs unless specified. Muslim law does not recognize joint family property. The estate is divided immediately after death. Disputes are resolved through family councils or courts. Let's now explore Christian and Parsi laws under the Indian Succession Act. For Christians and Parsis, the Indian Succession Act, 1925, governs intestate succession. Section 33 is key. It outlines how property is divided. If the deceased leaves behind a spouse and children, the spouse gets 1/3. The remaining 2/3 go to the children equally. If there are no children, the spouse gets half, and the rest goes to parents or siblings. For example, if a Christian woman dies leaving behind a husband and 2 kids, the husband gets 1/3, and each child gets 1/3. This law ensures equitable distribution but may not suit every family's needs. That's why a will is essential. It reflects personal wishes. Parsis have slightly different rules under the same act. The law also applies to Jews unless they opt for community-specific rules. Property includes bank accounts, land, jewelry, and investments. If there's no spouse or children, siblings and parents inherit. The act provides clarity and avoids ambiguity. Now let's talk about what makes a will invalid. A will must be made voluntarily and with full understanding. Section 61 of the Indian Succession Act, 1925, allows revocation if a will is made under coercion. If someone is forced or tricked into signing a will, it's legally invalid. For example, if an elderly person is pressured by a relative to exclude other heirs, that will can be challenged in court. The burden of proof lies on the person alleging coercion. Courts examine medical records, witness statements, and circumstances. If proven, the will is set aside, and intestate succession rules apply. This protects vulnerable individuals from exploitation. Fraud includes forging signatures or misrepresenting facts. Undue influence includes emotional manipulation or isolation. A registered will carries more weight in court. Witnesses play a key role in validating the will. Legal advice is crucial when drafting a will. Let's wrap up with key takeaways. Let's summarize what we've learned today. Dying without a will leads to intestate succession, governed by personal laws. Hindus follow the Hindu Succession Act, Muslims follow Shariat law, and Christians and Parsis follow the Indian Succession Act. Each law has its own rules and hierarchy of heirs. A will gives you control over your assets and avoids legal complications. Make sure your will is voluntary, clear, and ideally registered. Consult a legal expert to draft it properly. Protect your loved ones from future disputes. Also, update your will periodically as circumstances change. Include all assets and liabilities for clarity. Mention guardianship for minor children if applicable. And ensure your wishes are legally enforceable. If this episode helps simplify the law for you, don't forget to like, share, and subscribe to Law Made Simple. Your support helps us reach more people with clear, practical legal education.